Hello, and welcome to Free Speech Unmuted. My co-host is Jane Bambauer of the University of Florida. I'm Eugene Volokh, a senior fellow here at the Hoover Institution. Today, we're going to be talking about student speech, particularly not college student speech, but speech of students at public K through 12 schools. There's an interesting recent case. Jane, tell us about it.
All right. So what happened in this case called LM versus Middleborough, city of, I don't know, town of Middleborough. uh, a student went to school wearing a shirt that said there are only two genders, and then later he was asked by the administration to take change out of the shirt during his first period of school. And then later, his father talked to the administration, didn't think that the administration was in the right for requiring him to change his shirt. And he came to school again with the same shirt, but this time it said, there are, and then he had taped over the words only two so that it said censored. So there are censored genders. By the time he was wearing the second shirt, at that point, it was sort of a media fiasco. So I actually think for our purposes, we'll probably focus most of our time on the first time he wore the shirt. And so this tees up a question about what rights students in public K through 12 schools have when they are engaged in passive, at least what the courts call passive speech, meaning that it's not some sort of fleeting comment he made with his own voice. It's that he's wearing a message, and it has political overtones. But the school district thought that they were in the clear for requiring him to change out of his shirt because they were enforcing their hate speech related clothing rule. And so that rule said that clothing must not state, imply, or depict hate speech or imagery that targets groups based on race, ethnicity, gender, sexual orientation, gender identity, ding ding, religious affiliation, or any other classification. And so the school thought that his message, which, by the way, they sort of understood to mean, it's a little ambiguous, but that the school understood the message to mean there are only two sexes and each gender corresponds only with those two sexes. And so they thought that by wearing the shirt, he was basically denying the identities of some of his fellow students who went by, who were either trans or non-binary. So that's the background. The First Circuit decided that the school did have the authority, notwithstanding existing speech rights of students, to force the student to change his shirt. And the student's family appealed to or rather filed cert at the Supreme Court. The Supreme Court decided not to take the case, but Justices Alito and Thomas wrote a dissenting opinion on that denial of cert. And that in itself is somewhat interesting because Justice Thomas, at least, is sort of well known for having for criticizing the concept of student speech rights at all. So Eugene, I think it'd be helpful for us to know a little bit about the background precedents that were already in place by the time that the school district had to figure out what to do with his shirt. So why don't you tell us what rights students do have?
Sure. So the main rule when it comes to student speech in K through 12 schools comes from a case called Tinker v. Des Moines Independent School District from 1969. And there, the court concluded that students, and here when I say students, I'm going to mean K through 12 students, maybe just junior high school, not clear how it extends to elementary schools, though I think it probably does extend to elementary schools. Rules for college students are different. But that students, the court in Tinker held, have pretty substantial rights to speak in schools so long as their speech is not sufficiently likely to be disruptive. So that means substantial rights, but lesser rights than we have in public on the street. where we can say things that are disruptive, and so long as we don't, let's say, physically block building entrances and whatever else, we can't be punished because they're disruptive in the sense of likely to lead to a fight or to substantial distraction or what have you. But in school, speech can be restricted if it is actually or potentially disruptive, or at least if there is sufficient evidence of that. So that's the Tinker case. Substantial protection for K through 12 students against discipline, but more limited than in public. Now the court,
And maybe it's worth talking about what the expression was.
Right. That's a good point. So in Tinker, students were wearing black armbands to protest the Vietnam War. And there was some evidence that some classmates were offended, that there was some distraction. There was a kind of potential prospect, maybe, of fights or some such. People, of course, in the late 1960s, Vietnam War was a hotly controversial topic. Classmates were likely to have relatives and friends who were fighting and possibly dying in Vietnam. Might have taken this amiss, might have seen that as offensive, but the dissent pointed out that there was some degree of disruption, but the court said not enough to justify restricting this speech. Now, since then, the court has limited the rights provided by Tinker in a couple of ways. In a later case called Bethel School District versus Fraser, the court held that vulgar speech can be restricted. Sexually themed speech and the like can be restricted in school, even when it's not particularly disruptive. I'm not going to go into all the details of that, although I'm sure there'll be occasion in future episodes to talk about it, but it's really limited to vulgarities and to sexually themed speech. And there's also a case called Morse v. Frederick, known sometimes as the Bong Hits for Jesus case, because that is the banner that student displayed at a school-sponsored activity, which says that speech that basically, without any political content, advocates for drug use, presumably be the same for, say, alcohol use, which is illegal for minors, can also be restricted. So that even without a showing of disruption. So Tinker provides the general, fairly broad, but limited protection. And then there are a couple of these limitations. There was also then a later case called Mahanoy School District versus BL just a few years ago, just 4 years ago, where the question is what happens with off-campus speech. Court didn't fully resolve that question, although it pretty strongly suggested that off-campus speech by students, even when it might cause some disruption on campus, is going to be more protected than on-campus speech. But how much more protected, we don't really know for sure. So those are the main cases. One other case that, just for the sake of completeness, that might be worth mentioning, is Hazelwood School District versus Kuhlmeyer, which upheld a broad authority by the school over the content of student newspapers, the official student newspaper of the school. But that has more to do with the government speech doctrine, the theory that the student newspaper is essentially a voice of the school, even though written by students, than it does with the rights of students to speak on their own. So in any event, that's the big picture. And one of the things that the Tinker case does is it allows what is in other contexts called a heckler's veto. So this issue had come up before, where police officer sees someone speaking in front of an angry crowd, angering them, and the police officer says, well, there's about to be a fight or a riot or something like that. We're going to make you, the speaker, stop because of the danger of disturbance, breach of the peace, fights, maybe worse, that stems from public upset at your speech. As a general matter, the court said that kind of so-called heckler's veto is not permissible, except in extreme cases, The job of the police is to protect the speaker rather than allow those who are threatening the speaker expressly or implicitly to basically shut the speaker down. But when it comes to speech in K through 12 schools, at least as lower courts have interpreted Tinker, and I think probably as Tinker is properly interpreted, whether you agree with its holding or not, the heckler's veto is alive and well. If speech does seem sufficiently likely to disrupt school activities, at least in school speech is sufficiently likely to be disruptive, even when the disruption is simply people get offended, people get upset, and thus as a result try to attack the person, the speaker, or even just start shouting and interferes with class, let's say, then in that situation you can suppress the speaker's speech, and you can try to deter the speaker from saying these things because of a fear that offended students will violate the rules by disrupting them. By the way, something similar sometimes happens in government employment. That government employees, under the so-called Pickering test, which also has kind of a disruption element to it, can also be fired for saying things that sufficiently offend coworkers or members of the public. Exactly where that line is drawn is hard to tell. Like Tinker, Pickering in the government employment context provides considerable protection, but limited protection. But the things that they have in common also is that they do allow a certain degree of this kind of heckler's veto. And an interesting
And
question.
there is, oh, and I think there is some logic to it, though, right?
Exactly.
Because these are contexts where the government has a job to do. It's trying to accomplish something, something, sort of some sort of positive mission, and of course, nothing requires a school or a government employer to suppress the speaker, rather than using it as a teachable moment and training the rest of the people, the rest of the students, for example, to be less disruptive and to be able to handle difficult messages and whatnot. But it just allows them to, because there needs to be a certain amount of, I guess, expedience, I guess, if they really need to get something accomplished. Do you agree with that?
Oh, that's certainly a very plausible argument. I think it's an important argument. The government's position is, look, we've got a job to do here. And our job is to educate kids. And we can't do that if there's disruption. And it may be the fault of the offended students, but it's a reality. It's happened before. It's likely to happen again. We need to make sure they learn algebra. Likewise, in the government as employer context, they say, look, we have to provide services, provide police protection, for fire protection, and such. And if there's serious disruption to morale, if coworkers are offended by each other, don't really want to work with each other, if members of the public begin to doubt whether they're going to be treated fairly by government employees, that's going to interfere with our job. Now, of course, the policeman on the street corner also says he's got a job to do. My job is to make sure there aren't fights, and fights can turn into even worse. And the way to stop this fight is to shut up the speaker. But we tell him, no. And we know it makes your job harder, but you have to protect the speaker. But maybe the rule should be different in these kinds of managerial environments. So it's a perfectly plausible position. And that is, in fact, why the court has tried to reach these compromises. The one thing, though, that this means is that, excuse me, that the First Amendment in that kind of context ends up protecting basically speech that's not terribly controversial. And once speech gets controversial enough, and probably controversial plus disapproved of by school officials.
By the administrator.
School officials may tolerate some controversial speech, but not tolerate other controversial speech. Once it gets controversial enough, well, then in that case, then the government can shut it down. The thought is the real value of the First Amendment is precisely to protect controversial speech. The question is, what benefit do we get out of these speech protections if it only applies to non-controversial? The answer may be some, because, if the speech is maybe just offensive to the school, then the school can't suppress it just because of that. It also has to show some degree of likely controversy and sufficient degree of that. So maybe it's better to provide some protection, even if the most controversial speech is excluded. But we have to acknowledge that 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 is what's happening, and again that it's likely to be enforced in a particular way, which is when the school really likes certain speech that's controversial, then they're going to go to bat for it. But when it doesn't, then in that case, they're going to suppress it. The other thing to keep in mind, of course, is as with so many of these examples, the speech may be controversial to some, but is a very important part of public debate. That sometimes you say, well, why should we protect the speech of kind of Nazis? Well, it's almost never about Nazis, right? Occasionally it's about Nazis, but generally speaking, whenever there's an exception for Nazi speech or hate speech or whatever else, pretty quickly turns into something that is broad enough, or at least people try to turn into something that's broad enough to cover even pretty mainstream, or at least views that have maybe a majority support or at least substantial minority support. And they may still be bad views, but those are the very kinds of views that probably should be discussed by the public. So this is a classic example, right? Lots of people think that there are only two genders, and that when individuals say I'm neither male nor female or something like that, then except with very rare situations of outright physical disorders, let's say physical conditions where somebody might be born with both male and female genitalia or something like that, or chromosomal anomalies. Let's say physical anomalies. Setting those aside, people say, well, when those are just psychological conditions, there may be mental illness, and we shouldn't accept that as reality. Now, others disagree, but that's a very big part of debate. Likewise, there's a very big debate about what the government should do. So one message from There Are Only Two Genders is, look, whatever you might think, we as a society, including our legal system, shouldn't try to accommodate people's views that there are more than two genders. That too is a very important political dispute. Now, of course, it plays out differently in different contexts. My understanding is the view that there are men and women defined by biology, and that's the way we should operate, is actually gets majority support when it comes to things like transgender athletes competing on women's sports teams, at least looking at surveys. That's actually a popular view, even if it's unpopular among some people, including some school administrators.
Yeah, but it also might be context specific to sports, where there is a sort of zero-sum issue in the female category.
Exactly. When it comes to certain kinds of sexual privacy, for example, who should be allowed in spaces where women, for example, are nude. There's actually a very recent decision from the Ninth Circuit on that question, but outside of schools. I think there also is probably pretty broad support for some variants of There Are Only Two Genders, or at least some implications of that phrase. It's a slogan, and as such is not super precisely used. On the other hand, when it comes to, for example, whether the law should ban discrimination based on gender identity, there's probably majority support for indeed banning such discrimination, also substantial minority for the contrary view. So in any event, so what essentially the school in this case was saying is, it's okay for us to suppress this pretty important viewpoint while ourselves supporting and arguing for the opposite viewpoint. If you want to express the opposite viewpoint, that there are lots of genders, then by all means, please do that. We'll even perhaps praise you for it. But if you don't, we will discipline you. And ultimately, the discipline, if you keep violating the rules, may be suspension or expulsion. So that's one question is, should we say, look, this is so important that people be free to express these views, even in K through 12 schools, that we have to tolerate some degree of disruption as a result, or should we say, look, express yourself elsewhere? Of course, that raises the issue of whether the school can actually have 24/7 control over student speech and
let's assume the
suspend them for things
different
they say outside the school if they have disruptive effects in school. But that's at least an issue not raised in this particular case. It's actually raised in a case that I'm litigating. We're still waiting for a appellate court opinion on that, but not in this case.
Right, and
So
that's the
that,
Mahanoy question. Yeah.
yes.
Well, so yeah, that reasons nicely. It seems that what the school did and what the First Circuit adopted was that it used the logic of the Bostock decision, where the Supreme Court basically embraced transgender identity as one of the list of protected statuses, to then justify this, as you put it, this sort of asymmetric, um, this asymmetric sort of enforcement of speech on campus, so that saying something like there are only two genders is treated as equivalent as saying something just overtly racist, or like like some race is inferior or something. Like, imagine wearing a shirt saying that, right? And so the First Circuit, they avoided asking whether they avoided the question of whether the shirt actually literally interfered with the rights of other students, and instead focused on the question from Tinker of whether there was a substantial disruption, or material disruption, I should say. But in finding that there was material disruption, they thought that this was demeaning of a category that is specially protected, basically. And it follows it, or at least it's in line with some other circuits that had found that there's that the line here, clearly the shirt is pretty close to the line where based on where the circuits have drawn the lines before. So just to give a couple examples, the Ninth Circuit had found that a shirt that said homosexuality is shameful was materially disruptive, for the same reasons, more or less, that the First Circuit went with in the transgender, to protect transgender identity here. But at the 10th Circuit, someone wore a shirt that said, "Be happy, don't be happy, not gay." That was not demeaning. It was only, and I'm quoting here, tepidly negative. And so somehow that was found to not be likely to have the same level of disruption. And so I guess I have a couple questions. First of all, is that about, do you find this convincing that they're drawing lines and about the right place, given the overall goals of providing students from some free speech, especially because, as you said, the whole premise of Tinker is that students, as they age, need to learn how to debate with each other and find their own voice politically and whatnot. And I guess the second question I have is there once we have law especially protecting certain people based on identity, does that mean that there really is something different about political speech that's about identity? Like, identity politics might actually get this special carve out even within political speech, in a way that military families, for example, because it's not a protected identity, even though it could be core to somebody's, to some students' sense of self and pride, because it's not a legally protected identity, their sort of sense of offense from an armband during the Vietnam era would not raise the same sort of, I don't know, legalistic treatment.
Right. So I think you've hit the nail on the head here. Excuse me. So far, what I was talking about is the big picture rules from the Supreme Court, with especially coming from Tinker, which really is just focused on the question of disruption, and the disruption can come from whatever viewpoint is sufficiently offensive to enough people. But in this case, the First Circuit tried to particularize that some. And it focused less on people simply being offended, but the argument is that they're negatively psychologically impacted. And the First Circuit articulated a test and said school officials may bar passive and silently expressed messages. And surely that means they can also bar oral statements as well as T-shirts, but may ban even T-shirts by students, even when that targets no specific student. So it's not like individualized bullying.
Mm-hmm.
If the expression is reasonably interpreted to demean one of those characteristics of personal identity, given the common understanding that such characteristics are unalterable or otherwise deeply rooted, and that demeaning them strikes a person at the core of his being. And two, the demeaning message is reasonably forecasted to poison the educational atmosphere due to its serious negative psychological impact on students with a demeaned characteristic, and thereby lead to symptoms of a sick school, symptoms, therefore, of substantial disruption. So, on the one hand, the court is trying to be more specific and narrower than just anything that's disruptive. And it targets speech that it sees as likely to have actually negative psychological impact, and focuses on particular kinds of speech that's demeaning of characteristics of personal identity. At the same time, in being this narrow, the court embraces, that is to say, the First Circuit. The Supreme Court did not agree with the First Circuit. It just declined to
Mhm.
review the issue, and the Supreme Court has repeatedly said that's not a Supreme Court precedent. That just lets the lower court decision stand. The issue may come back up to the court at some point. The First Circuit essentially said they're adopting kind of a quote hate speech, close quote, quotes mine, but kind of that's the kind of thing that the label that people have used, even though the First Circuit didn't. Exception when it comes to K through 12 speech. Frankly, viewpoint-based exception, that there are certain viewpoints that we view as demeaning of identity that as a First Amendment matter are just not protected when it comes to K through 12 speech. As a matter, so that's just a First Amendment rule that is itself a viewpoint-based rule within a doctrine where the Supreme Court has generally said, by and large, the worst thing that the government can do is to set up viewpoint-based speech restrictions. Well, here,
Mhm.
the First Circuit was essentially saying the First Amendment itself adopts this viewpoint-based distinction between speech that is demeaning of characteristics of personal identity and speech that expresses other views or perhaps even contrary views, praising certain characteristics of personal identity. So again, one might say, well, maybe that's proper. Maybe, maybe we should have broader hate speech exceptions. There is no such exception under the First Amendment law. The Supreme Court has made that clear, but some people disagree. Or maybe when it comes to K through 12 education, whether it's because of the institutional setting that the government has a mission, or because there are children involved, or maybe we should have this kind of exception, even for political advocacy. That's very much a part of current debate. Um, uh, uh, so so that's possible. But one could also say, look, this is a dangerous precedent to adopt a viewpoint-based First Amendment limitation, even in the K through 12 school context, and especially because we see in this very case that it's being used to restrict serious discussions. After all, this isn't just about there are only two genders, right? Let's say somebody just said, "Look, yeah, absolutely, I think that." Up until a few decades ago, we used to think that when people who have a particular biological sex believe that they are of an opposite sex or opposite gender, that was seen as mental illness. And maybe that's right, maybe not, but we at least ought to be able to discuss this. That too is just as much punishable under the First Circuit's test. In fact, it's hard to see how one could have a serious discussion, whether in class or in the cafeteria, on a subject like this, where one side can get you suspended or expelled, and the other side, well, you're perfectly free to express. Now, one possible
Well,
answer is maybe it's better if these discussions don't happen in schools, or maybe this is one area where really we should propagandize students because we think there's the right answer that is psychologically helpful to classmates. But I just want to highlight what kind of a big step the First Circuit took.
yeah. Well, it seemed that there was a little breadcrumb that allows maybe other courts dealing with different facts to avoid the full breadth of this ruling, because they do distinguish the T-shirt sort of bumper sticker slogan from what they called, let me get the passage here, expression that is fleeting or admits of nuance. So something about fleeting maybe matters because it's not, maybe it's only heard by a specific audience for a small amount of time or something. But the admits of nuance, that, it's a vague phrase to hang too much on, but
Right.
maybe the idea there is that something as simple as an armband or a t-shirt doesn't actually progress debate that much anyways. I mean, I have to say, I'm sort of sympathetic to that idea a little bit, except that if we go down that road, then it seems that Tinker was also decided wrong because
Right, right. The
so
black armbands in Tinker were not
yeah,
fleeting or
not
admitting of
nuanced.
nuance. Um,
Correct.
but beyond that, first as to fleeting, um, you know, it's true that a conversation that you overhear is fleeting. It's likely to be done in a few minutes, whereas the T-shirt, you'll see again during the day. On the other hand, if one student can engage in a conversation, other students could too. And in many ways, I think
Yeah.
it's people get more upset at overhearing something that they can't avert their ears, right? I mean, they can move, but
Mhm.
there they are sitting at lunch, and then somebody next to them is saying, in a perfectly calm tone of voice, but saying, look, I think that society has gone down the wrong path in recognizing more than two genders. I think there are only two genders, and keeps talking about that. At least with a T-shirt, you can avert your eyes. You can't avert your ears with a conversation. And as to admitting
Well,
of nuance,
that's true, but on the fleeting point for a second, it might be though that when someone's wearing a T-shirt, then there's a reaction of uh, uh, there's not a back and forth as much as maybe a likelihood that other people will then wear T-shirts that try to counter the message. I can imagine maybe the medium being the issue, where uh, where students who put into practice sort of claiming their beliefs all over their apparel induce other students to do the same thing, whereas a back and forth conversation maybe
right.
is
So I suppose, although if you're really worried about students kind of escalating and having more and more message-bearing T-shirts, and that's more and more distracting, it's
yeah,
funny
they'll
that
look
you're
like
picking on
NASCAR
this
drivers.
particular message, whereas the
Yeah,
opposite
that's true.
message, which maybe, let's say somebody wears there are only two genders T-shirt in response to a transgender pride T-shirt.
Right, right. Yes,
One of those is being targeted, and not the other. But
fair.
and again, as
Yeah.
to admitting of nuance, I entirely agree. I think our views as educators is we wish that our students, college students, but probably would wish the same thing if we were teaching high school, would focus less on slogans and more on real discussions. But the
Right.
problem is, first of all, again, the school tolerates a lot of speech that is not that is not particularly nuanced. But also, like,
Mhm.
how do you know as a student when what you say is likely to be seen as sufficiently unnuanced? Like, say,
Yeah.
well, you could have expressed your views, but just with more nuance. Well, how much more nuance? I
Mhm.
thought it was pretty nuanced. No, 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 you weren't nuanced enough. You didn't consider plausible counter arguments. I consider this one. Well, that's not nuanced enough, right? Right. That can't be a First
Yeah.
Amendment test. I mean, the court may have been explaining that in this case that it was missing sufficient nuance, but that cannot possibly be a legal limitation on this First Amendment test that it announces. By the
That's
way,
probably right. And oh, go ahead.
I should say that courts have generally said that that schools can implement dress codes
Yeah. Okay.
that says basically
Well,
you have to wear a solid blue shirt and tan slacks,
yeah.
or that would be uniform actually. But you could
Right.
even
Uniform.
say
Yeah.
a dress code that says you have to wear a solid shirt and solid slacks or something like that.
Or no
Um,
messages on the shirts or
Right.
something.
And note that is actually a much broader restriction on student
Right.
speech, right?
Yeah.
Students are still free to say things, but they lack the opportunity to express themselves through the T-shirts. But it's content neutral, and courts have
It's
upheld
content.
it on those grounds. And
Okay.
that's a recurring question in First Amendment law. Do we want to have broader restrictions on speech, but at least are content neutral, or do we want to allow the government to narrow them, but narrow them in ways that are content based and perhaps even viewpoint based?
Well, let me even try an argument that maybe it was only barely about the T-shirt anyway. This might be too clever, but I kept thinking about it as I was reading the case. So So his shirt actually said there are only two genders. It did not say that, he doesn't recognize someone who's born of one sex who identifies as the other gender, right? And so if the shirt denies the existence or validity of anything, it would only be the non-binary, the they them students, which I don't think Bostock, I went and looked to see if there was any reference to non-binary in Bostock. I don't think that at least the Supreme Court has recognized non-binary as opposed to transgender as a protected category. And yet everyone on campus knew what he meant.
Right.
But if they already know what he means, then his own face is the message, right? They don't like this kid because they know, he had worn other sort of political shirts before. They kind of assumed they knew the full package of his beliefs, and they interpreted his shirt accordingly. And so I think, this leads me to think that there really is to agree with you that there's a problem of viewpoint non-neutrality if they're not even sticking to the literal words
Right.
of the shirt.
Well, slogans often do acquire meanings that are different from
True.
what they literally say.
Okay, that's a fair point.
Right. So a common gun rights slogan is guns don't kill people, people kill people. I mean, really, guns don't kill people? No, what they mean is you shouldn't attribute a murderer's, you shouldn't attribute culpability to the gun. You should focus on the murderer, and that the
Right.
murderer would have killed in other ways or whatever else. You could agree or disagree with the slogan, but I don't think it makes sense to parse it hyper literally. And the same
All
thing
right,
is true with very many liberal slogans. Like, well, somebody saying, let's say, wear a T-shirt saying pro-choice. It's you're in favor of choosing to eat animals, right? You're in favor of choosing to, I don't know, to kill people, right? That's a choice too. No, I'm not saying that. But pro-choice means something very specific in our current debate. Maybe there are only two genders is a little bit less clearly tied to a particular to a very, very particular message. But I think it makes sense that we would interpret it, that a court would say, look, school might interpret it as it's commonly understood. And that in fact, and that the speaker could say, look, people understood what I meant, and don't be too literal about the reading.
Yeah, that's what I figured. I was being a little too well, I called it clever, but you're right. I'm probably actually being too narrow or literal. So yeah.
Well, this is one of the things we sometimes do as academics,
well, also,
and sometimes we try to avoid it.
The court itself, though, talks about how one problem with the shirt is that it denies that it communicates that there are only two, and denies, the non-gender non-conforming. And, if we're only focusing on that subsection of the population, then I think some of the hate speech, taking advantage of protected categories starts to go away. But anyway, okay. So what else is there to say about this case then? Maybe do you want to explain a little bit about? Do you have any thoughts about the dissenting voices who really wanted the Supreme Court to take the case?
So I do want to signal one interesting feature of this decision. There are two dissenters. One is Justice Alito, who has generally spoken out before about freedom of political speech in schools. He has written separate opinions which stress that schools should have much more limited authority to restrict political speech there, and even more so out of school. The other one is Justice Thomas, and Justice Thomas, like Justice Hugo Black in the Tinker case, has taken the view that basically First Amendment rights don't apply at all to school discipline decisions in K through 12 schools. So what he said was, look, under current law, our precedents say that First Amendment rights do apply unless there's sufficient evidence of disruption. And I agree with Justice Alito that given that Tinker's binding precedent that lower courts must faithfully apply, the lower court got this wrong. But he would say, look, we should just avoid all these problems by just leaving things to school authorities. And if school authorities want to restrict supposedly unpatriotic speech or anti-war speech or whatever else, that's fine. And the corrective to that is political, right? That if
Mhm.
parents don't like it, they can elect a new school board. And another corrective is people pulling their kids out of school and send them to private school, which may impose their own rules, but ones that the parents like. And of course, private schools cost money, although, to be fair, Justice Thomas has also been one of the voices on the court who has spoken out in favor of constitutionality under the Establishment Clause of school choice programs, among other things, because they provide more options for parents.
Yeah.
That the parents can choose whether to send their kids to religious schools or to more free speech tolerant schools or whatever else. But I think one thing
So
that
he has a fully thought through alternative model, but since we're not doing that package and we
right,
are under the
right,
tinker
right,
and other constraints that
right.
we are, then we ought to at least apply the rule in a
Right.
viewful way.
So one thing that this reminds me of is something that I observed in many past cases as well, which is just the similarities between Justice Thomas and Justice Hugo Black. So Black was a very liberal justice. Thomas is very conservative. Uh, uh, but they both understand themselves as originalists. Black framed himself as a liberal originalist. They're both, I think, somewhat more open to categorical rules rather than balancing tests or tests that focus on things like disruption. And in this particular context, Justice Black was the leading, even though he was quite liberal and K through 12 school rights were generally associated with liberals at the time. He dissented in Tinker and said, "Look, we should not put ourselves in a position that of second guessing school decisions. Let's just have a categorical rule. The schools can impose whatever restrictions they want." Justice Thomas is now saying something similar. His arguments are even more historical than Black's. He points to longstanding history of these kinds of restrictions, or at least what he understands to be longstanding history, these kinds of restrictions. But pretty similar in many ways. There are other such examples. Interestingly, Justice Breyer, in many ways, is similar to Justice Felix Frankfurter, who also served at the same time as Hugo Black did. Very much different from Thomas and Black, very much more into balancing, into kind of case by case adjudication, and the like. The last thing that I wanted to mention, though, is something that I heard from a law professor. I wish I remembered exactly who it was. I think I remember, but I don't want to get it wrong. So let's just say credit to someone else who's a very liberal professor. And again, liberals have generally been associated with the notion of free speech, even in government-controlled domains. But he said, look, we have this rule that parks are open to public speech. Okay. But, a lot of people don't like going to a park and seeing a demonstration there and hearing messages, whether they're offensive or loud or whatever else. And rich people have nice big backyards. Rich people belong to country clubs. Rich people can go to other places where they've got lots of seclusion and can play with their kids and have fun, and they can kick out anybody who wants to demonstrate there. What if a city says we want to give up our poor citizens and middle class citizens the same kind of thing? Well, no, you've got to protect free speech. Okay, but aren't you then denying, through this speech protection, denying to ordinary citizens the things that rich people have? You could say very much the same thing about schools, too. I think a lot of parents who send their kids to private schools do it in part because they want the kids to go to an environment that inculcates certain values that they like, even by restricting expression of other values. Now, to be sure, some parents may want to send their kids to schools precisely because they're broadly open. But many parents, whether they're religious parents who want to send their kids to a religious school, or liberal parents want to send their kids to a school that teaches liberal values, or conservatives want to teach conservative values, if they have the money, they can do that. But Tinker essentially says, well, whatever those benefits are of private schools that many people perceive for their kids, well, this is one kind of benefit you can't have in public schools. because it's so important to protect the speech rights of the students, again, only in public schools, because the First Amendment doesn't apply to private schools. So, I'm not sure how persuasive this argument should be, because there are good reasons to protect speech in public parks and public schools and
Right.
and
And
such.
especially
But
because Tinker does, it does have that material disruption
right,
option.
right.
So, um,
So in fact, or maybe a variant might be, we need to have a material disruption option. Every private school would certainly restrict speech that is disruptive. And if it
right.
didn't, the
Yeah.
parents would demand it, because they say,
Yeah.
we are sending our kids to school to learn various subjects and not just to say
Yeah.
whatever they want to say. Well, shouldn't
But then
public schools have the same authority?
Yeah, okay, at least the First Circuit suggests that they do, but if they enforce the no material disruption along one ideological, direction and not another, does that undermine the entire rule? Yeah,
Um,
yeah, I find I understand. Like, I'm glad I'm not a public school administrator, because I get the problem. I think this, if the administrator was here, they'd say, well, some messages do have differential impact on the students, and based on viewpoint, right? That a general viewpoint saying everyone is accepted. If you don't believe that, you still haven't necessarily personally been harmed by the idea of open acceptance. Or at least it's hard to make that case. It's much harder to make that case than to make the opposite case, that somebody who's denying the acceptance of some belief or identity is excluding and indirectly at least targeting a subset of individuals. So
right.
yeah.
So in any case, these are, I think, all the arguments. I think this is a it sounds like you do too, it's a very difficult area. I sympathize with school administrators. I sympathize with judges who are trying to parse the precedents, but also think through the practical realities that administrators face. And of course, with things like the Israeli-Palestinian conflict, this just highlights the difficulty of some of these things. On one hand, the First Circuit's test would allow the suppression of a good deal of anti-Israel speech on the theory that, set aside whether it's anti-Semitic, there may be students in the school who are Israeli,
yeah,
either Israeli American, but may just be Israeli, maybe Israeli citizens,
right,
and somebody's saying, "Oh yes, I think that the Palestinians are quite right to try to destroy Israel, and I think Israelis are guilty of war crimes, and every Israeli is complicit in that." Not my views, but I think views that are an important part of the debate. Well, that could be restrictable. Likewise, speech that says, well, Palestinians are dying in Gaza, but that's what happens when your government attacks someone else and then uses you as a human shield. Look, we 3,000 Americans were killed in Pearl Harbor. How many Japanese including Japanese civilians, did we kill in response?
Okay, Eugene, but if the high school students say that level of detail on each side, I would be happy. I would be so happy.
Right. In a sense, you might at least say,
laying out the debate in a much better...
Right. At least that is something more than just slogans. But you might be happy, but lots of people won't be happy, right?
Yeah,
Classmates won't be happy. Teachers may not be happy. Parents may not be happy. School administrators may not be happy. So one possible argument is, look, that shows the problem with the First Circuit's position, because it suppresses all of this advocacy on all sorts of topics, a particular set of topics, but lots of different versions of those topics. On the other hand, you might say, well, yeah, the First Circuit was right. You got to be able to suppress speech like that, because otherwise students won't be learning algebra. Back to algebra.
Always back to algebra.
It's a very difficult question, but I hope at least we've explained some of the legal nuances that come up there. And we tried.
And we didn't mention President Trump once.
What do you mean? You just did.
Still, it's hard to go a show without President Trump in the mix. So yeah. All right. Well, great to see you.
Great seeing you as always, and we'll have another one of these in a couple of weeks.
This podcast is a production of the Hoover Institution, where we advance ideas that define a free society and improve the human condition. For more information about our work, or to listen to more of our podcasts, or watch our videos, please visit hoover.org.